Hi everybody, I'm JD Hoovener, your host of the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. Hey, we're in part 2 of our series talking about pre-filing considerations. I'm excited to share with you some of the big input that I get from a lot of clients and some confusion about differentiating between inventors and owners. So inventors, of course, are those that actually have a creative input into the invention, right? They've come up with some substantive ideation and creativity that goes toward the eventual creation, the heart of the invention. Owners, on the other hand, or otherwise known as assignees, just own it, right? They have the legal rights to, once that patent gets granted, to exclude others from making, using, selling, or importing into the U.S. But it's certainly a huge, critical, important part right up front. Before we do any kind of patent searching or developing a patent application, we need to make sure that we're working with an inventor that has clear goals and objectives, and they know what rights they're going to have. Sometimes we do end up having clients that are employees at big companies, and sometimes their invention, even though they've developed it, right, off hours, on the weekends and nights, they're using the company laptop, they're using the company phone, and maybe they're working on breaks or at lunch, and the project is actually pretty closely related to what they do at work. That is actually, all of those points lend toward the company owning the patent, and they're actually going to be the ones that have the assignment obligation per the employment agreement that the inventor likely signed. And so it's really important to clear up right away before the employee comes up and pays for this, that they know that there's actually a big chance that the ownership of this invention would belong to the employer. And if the inventor wanted to sort of keep it quiet, the attorney really wouldn't be able to help them, because it's likely going to come back later. If the inventor were to try to bring that forward and try to enforce that against a would-be infringer, the employer is going to come back and say, no, I don't think so. And so what's going to happen is we need to have that full conversation right up front to make sure that's all clear. Another misconception with inventorship is a lot of people think that a party A, for example, all they do is come up with the groundbreaking idea, right? They've got that inspiration, that creative and inspiration of that idea, and party B is the one that actually builds it, brings it to life, figures out which parts work, what kinds of materials work, and they bring the prototype to life and get it functional. Who do you think is the right inventor, party A or party B? The answer, surprisingly, is only party A, the one who conceived of the idea, brought into life that invention, not the one that brings it into reality, not the one that builds it and actually just follows the instructions. So it's a big interesting concept that even though party B did all the work, they did tons of effort in bringing it to life, party A was the one that conceived it. Party A alone should be named on the patent application. So I hope this has been helpful for all of you out there, business owners, entrepreneurs, and inventors. If this has been helpful and you think it might be helpful for someone just forward the email to them. They're going to get this information, be able to get the daily email just like you do. So I hope you all had a wonderful day today, and I'm your host, JD Hoovener of the Bold Today Show. Go big, go bold.
Go big, go bold.